Thank you, Peter. Dear all, it's a great pleasure and honor to have the opportunity to be in Strasbourg again since 2016 and to participate in this conference which concern a very fundamental aspect of the freedom of expression, especially nowadays. And after Marcus, I will continue from a perspective of a practicing lawyer in human rights concerning this, the focus of this session. Let me begin by noting that the press is the key element of public accountability in a democratic society. What does it mean being a key element for public accountability, especially in covering protests? I will underline here, please, the screen.
Screen? Oh, that. What did you do with it? Oh, it's done it.
Okay. I will underline here paragraph 75 of Selmani case, which I consider like a reinforcement of the role of the press during protests. This paragraph 75 of Selmani case. And in this paragraph, you will see that the court underlines that the presence of the press during a public event is a guarantee for the accountability, for public accountability, for the public authorities, for their conduct vis-à-vis the demonstrators and the public at large. And you will see again, any attempt to journalistic activity during a protest may be subject to a careful examination, firstly of the national courts and finally of the human rights court. In this regard, maybe a question arises. Does this high importance accorded to the journalists covering protests immunize them from their duties and responsibilities while covering a protest? As the court said in famous Pentikainen case, in dissenting opinion also we will see, a journalist has an obligation to act compatible to the law, particularly in the context of the protest, taking a direct and active part in violence or hostilities during protest will not be protected under convention. However, a question. Marcus is a journalist, I'm a citizen. During a non-peaceful protest, is there a special status for a journalist while covering? There is a need for a special status for a journalist while covering a protest? I mean, could we, Marcus and me, in the same position in front of the police about a police dispersal order? In comparative law, you will see in paragraph, you will see in the paragraph 57 and 59 of Pentikainen case, there isn't any different special status accorded to the journalists in European countries. But it is worth to mention here the special OSCE report, which provides that the authorities have a constitutional responsibility not to obstruct the work of the journalists during protests. We have a very concrete case of the court on this issue. This case concerns a general ban, general police ban to access to a demonstration in Gizel case. There is a general police ban issued without distinction made by the authorities between journalists and demonstrators. And the court said in this decision that, in this judgment, that the inability of the journalists to access to Davos, to World Economic Forum, had not been prescribed by law. Because the court has taken into account that the public authorities didn't make a distinction between journalists and the others. However, in this case, if we provide a special status to journalists covering protests, who will profit from this status? Only a journalist who is wearing a distinguishable clothing or having a press card? Or simple verbal identification as a journalist, is it sufficient for it? This reminds me, for example, the facts of Göktepe versus Turkey case. In this case, the Turkish authorities didn't allow the journalist to enter, to access to the demonstration area because he didn't have a yellow press card. According to the special report of OSCE, there is no need for a special accreditation to cover demonstrations. That's the rule. Similarly, in Najafli case, Azerbaijan case, the court said that the applicant was wearing a badge and had explicitly identified himself to police as a journalist, and he had been subjected to ill treatment, and there has been violation of Article 10. So the court takes into account the identification element in its assessment test. Against this background, in Pentikainen case, even though the applicant, Marcus, identified himself as a journalist during his apprehension, the first step of the intervention, the court concluded that the conviction as a whole could hardly have a chilling effect on the work of the journalist at large. That was the conclusion of the court, and in my eyes, this last sentence, this conclusion remains a little bit problematic. Why? Because the conviction, the prolonged prosecution, or extended detention of a journalist itself is likely to discourage the journalistic activity. And in a very, very recent case of last week against Iceland, Olafsson versus Iceland, the court repeated that and said that irrespective of whether or not the sanction imposed was a minor one, what matters is the very fact of the judgment being made against a journalist. So, after Marcus' case, which is considered by the dissenting judges a missed opportunity in this area concerning the role of the media during protest, I think recent Selmani case is a welcome step in respect of the safeguard of the journalistic activity, especially by covering a protest, because this case, Selmani case, is based on the right of the journalist to cover public events and the right of the public to receive the information about an event, and not like Pentikainen case on the fact that the journalist reported finally, despite all the restrictions imposed on him during a protest. Indeed, as a conclusion remark, indeed, if you mitigate, as a court of human rights, if you mitigate or undermine the importance of the first-hand and direct knowledge for a journalist who imparts information on a public event, this may mislead the future conduct of the public authorities when policing a public demonstration. I mean, keeping in mind the dialogue between the standard setters of international institutions like OSCE, Council of Europe, and Human Rights Court, and of course the national authorities, Human Rights Court should assume the role and should provide some guiding role to remind the public authorities their positive obligation, in my eyes. In my eyes, it is a positive obligation to make a distinction between media workers covering a protest with or without badge, yellow press cards, but of course without taking part in disorder, in hostilities, covering in the protest, and the other demonstrators. What about the national authorities? According to me, they should avoid concentrating blindfold and a general and strict application of the law if a journalist covering a protest is at stake. This is also an important safeguard against obstructing and maybe silencing the journalist covering the protest or public events. This decision of the public authorities may be issued on the basis of arbitrary decisions, and this may lead to an open discussion, maybe for you, if you want, about the application of Article 18. But it's up to you. It's an open question. Thank you very much for listening.